Now let's talk about that U.S. Supreme Court case coming out of Southern Oregon and the city of Grants Pass. We've covered it extensively here on The Story, but tonight we're getting a perspective from a constitutional law professor, since this case deals with the interpretation of the Constitution's Eighth Amendment regarding cruel and unusual punishment. On Monday, the Supreme Court will hear arguments in the case, which could have big implications on the homeless crisis and how it's managed across the country. Here's a quick refresher if you're not sure what the case is all about. A group of homeless people sued the city of Grants Pass over several ordinances that would fine or jail people who camp on sidewalks, streets, and in parks. The Ninth Circuit Court, that's the court that covers cases in the western U.S., ruled in favor of the homeless people. They said the anti-camping ordinance violated a similar case decided in 2018. That landmark ruling, Martin v. Boise, says that governments can't punish people for sleeping outside if there isn't enough shelter available, ruling that violates the Eighth Amendment. But that was in 2018, and since then, the homeless crisis has gotten worse in cities across America. That's why, according to law professor Norman Williams from the Willamette University, the High Court decided to take up the Grants Pass case in the first place.
Overall, I'm fully expecting the Supreme Court to side with Grants Pass here. I think the U.S. Supreme Court, not to put too fine a point on it, a court that is unwilling to say the Constitution protects a woman's right to choose is going to be even more hostile to the notion that the Constitution protects the right to be homeless or to camp in public parks. So I think the court took this case precisely with an eye to reversing the Ninth Circuit's decision.
Attorneys for Grants Pass are arguing that the Martin ruling tied their hands when it came to homeless policy, and they've got support from state and city leaders from across the country on both sides of the aisle. California's Democrat Governor Gavin Newsom filed a brief with the court, siding with Grants Pass, along with attorneys general from Idaho, Montana, Nevada, and other western states. Even states on the East Coast joined in, all in support of Grants Pass. Now, Williams says those briefs are a big reason the Supreme Court decided to hear this case.
I mean, what's really striking is how many states, how many counties, how many cities here on the West Coast, governments run by liberal Democratic mayors and governors have filed briefs with the court saying that this is unworkable, that allowing for the homeless to have a constitutional right to sleep in public parks, to sleep on sidewalks, even in streets, is only hampering the ability of state and local governments to develop a comprehensive solution to homelessness. And I think those briefs will resonate with the U.S. Supreme Court, which will view this problem of homelessness as one best left to the political process and for experimentation in public policy solutions, rather than as, in some sense, being restricted by the Eighth Amendment's cruel and unusual punishment clause of taking away one of the tools that state and local governments have used to deal with this problem.
Now, when it comes to the Eighth Amendment prohibiting cruel and unusual punishment, Williams says he thinks the court will decide that fining and jailing people for sleeping outside isn't cruel or unusual enough.
The Eighth Amendment's cruel and unusual punishment clause speaks of punishment. It's really there to address torture, capital punishment. It's not there to address what type of conduct can be criminalized in the first place. The Ninth Circuit proceeded on the assumption here that any fine, any jail time would itself be cruel and unusual if you were involuntarily homeless, if there were no shelter beds available within the city, which was the case in Grants Pass in the Ninth Circuit's view. And Grants Pass, as it has emphasized in its brief to the court, has very small fines applicable to this. It only jails individuals who have been repeatedly found to have violated the city camping statutes, and Grants Pass emphasized that it issued fewer than 100 citations per year.
So we will let you know how the case plays out. It will likely take months for the U.S. Supreme Court's opinion on the case. But in the meantime, what's your prediction? Will the Supreme Court decide that cities can fine or jail homeless people? Or is it cruel and unusual when there isn't enough shelter? Let us know your thoughts. Send an email to thestory@kgw.com or call us and leave a voicemail, 503-226-5090.